everyone. Today we have our favorite attorney with us again today, Mr. Brandon McGee with McGee Law Firm. And he is going to be speaking about the 7 things you should know about estate planning, all very important. I am Zoe Frost with Celebration Magazine Live, and we had 87 people registered for today. We're going to keep this brief with me because we got a lot of learning to do today. And I am going to turn things over to Brandon. Brandon, take it away.
All right, thank you so much. And Mitch here is going to help me try and get a shared screen up so that we can also see some slides while we go through this. Okay, there we go. So Zoe, can you see, is it a good split screen, shared screen?
Yep, looks good.
Okay, wonderful. Let's get started. So as Zoe said, my name is Brandon McGee. I'm a local attorney. I have 2 offices in the DFW area, one in downtown Fort Worth and one in South Lake. I do focus my practice on estate planning and elder law. So that is what we do at this firm. We don't have 5 different areas of practice, and this is one of them. This is what we do, what we love, what we enjoy. Just briefly about myself, I'm a DFW native. Attended Texas Christian University in Fort Worth, left DFW for 3 years, went to Atlanta, Georgia to attend Emory University School of Law, came back, been licensed to practice in Texas since 2002, and I'm a member of a couple national legal academies that we'll look at here in a minute, or here right now. How about that? One is the American Academy of Estate Planning Attorneys. It's National Academy. All the members are highly vetted before we are let in. So this is not an academy that you can just join if you're willing to cut a check and you have a law license. Also, we are limited by region, and I'm very honored and happy to be the lone DFW representative at the moment. I'm also a member of NALA, National Academy of Elder Law Attorneys. This is an organization that if you're an attorney, a licensed attorney, and you write a check, they will let you in. So there was no special criteria. That being said, just like with the American Academy of Estate Planning Attorneys, lots of great legal practitioners or members across Texas and across the U.S. We get lots of great up-to-date information about, changes in the law, cutting-edge legal decisions, things like that, and a great network of other like-minded professionals to network with. I also have a A+ rating with the Better Business Bureau, of which we are a member. And this is my family here. And I just want to talk to you real quick about why I became an estate planning and elder law attorney. And so that you kind of have a sense of why I'm doing this and why I have a passion for it. So when I was in law school and when I got out of law school, I never remotely considered being an estate planning attorney. It just wasn't something that sounded exciting to me. I wanted to be a trial attorney, what we call a litigator. And so that's what I did. And when I was a younger attorney, I really enjoyed it. It was fast paced, exciting, all the things I kind of wanted. Then I got married and I had kids. And you see my wife, Rita, she's actually a fee attorney with Capital Title in Fort Worth. And our twin sons, Cole and Hunter, they are fraternal twins. And so once I got married and started having kids and different responsibilities in life, I actually started to get kind of burned out on the litigation. I was kind of driving to work in a bad mood, thinking I don't really want to be doing this anymore when I used to really enjoy it. It's very stressful. It can be late hours and just wasn't the lifestyle I wanted for the rest of my life. But I really honestly didn't have the courage to do anything about it. It's just what I did. And then in the year 2012, some calamities befell my family. First, and probably foremost, given that I'm married with kids now, my wife Rita was diagnosed in May of 2012, so almost 9 years ago, with stage 3 breast cancer. And this is something that, like any of you that have dealt with that diagnosis in your family, particularly if somebody's on the younger side, was very shocking. And, I still remember sitting in the doctor's office, receiving the diagnosis, sitting with my wife, and it was like an out of body experience. It's like, wait, this isn't us. This doesn't happen to us. This happens to other people. We don't get cancer, but we did. She did. So we started having to deal with that and grapple with the reality of that. Rita started chemotherapy immediately. And then about 35 days later, on July 1st of 2012, my father, at the age of 64, died of a massive and sudden heart attack in his backyard in downtown Dallas on Sunday, July 1st. Not downtown Dallas, excuse me, Dallas, North Dallas. But he passed on July 1st. It was a Sunday, middle of the afternoon, completely unexpected, completely out of the blue, just like my wife's cancer diagnosis. So coming out of that year, during the rest of that year, I started thinking a lot about things, and that, life can be short. We don't know which day is our next. We might as well get up every day and enjoy what we do. Like, why would you live your life not getting enjoyment out of what you do every day? It just doesn't make sense. So I came to that conclusion. At the time, I had a much smaller part of my practice, which was some probate and some estate planning. And I always really enjoyed the estate planning because it gave me an opportunity to set my clients up to avoid problems. Okay, so we're all going to have things happen in our families. People are going to pass away. People are going to get sick. People are going to need to go to nursing homes. People are going to lose their mental capacity. Some of these things are going to happen to all of us, not all of them to all of us, but some of them are going to happen to all of us. And there's nothing we can do about that. But what we can do is we can set up things so that legally, so that when they do happen, things go as smooth, as stress-free as possible for the family members who are left to deal with it. And so for me, that had a strong appeal because most of my career had been spent dealing with the train wreck, picking up the pieces of the train wreck instead of trying to prevent the train wreck. So coming out of that year, I decided to switch gears on my law practice, kind of a carpe diem, seize the day kind of mentality of, this is a risk, but this is what I'm going to do. And Rita was supportive. And so that's when I started estate planning and elder law exclusively. And it's one of the best decisions I've ever made. I love it. I go to work in a good mood every morning, drive home in a good mood most evenings. Here and there, something comes up, that's stressful, but for the most part, I really enjoy it. And the best news of all is that my wife, Rita, is in October, will be 9 years, no evidence of disease. So that's what led me to right now at this moment talking to you guys. Okay. So let's move on past my information, and we are going to have questions at the end. So please hold your questions. I'm happy to answer them. Anything I talk about that you want more information on or clarity on, please go ahead and do that. And then I might need Mitch to come in here real quick. Hold on, guys. Something happened with this screen. Excuse us. So went back to that screen. Okay. Questions. Questions. Okay, thanks guys. Sorry, I probably hit something accidentally or the computer did something. I apologize. But again, hold your questions to the end and I'll be happy to answer those, okay? So, all right, 7 things we're gonna look at here, 7 concepts. Number 1 is one size does not fit all when it comes to estate planning. So just because your sister or your neighbor or your best friend in Arkansas has a certain estate plan, it doesn't mean that it's right for you. Okay, it might be or it might not be. It might be that they don't even hardly know what they're talking about, or they may, and it's just something that's good for them because of their circumstances. So it's just like all of our families are different. There's no one size fits all with estate planning. Everybody needs to have their plan custom tailored to their family circumstances, their personal circumstances, their assets, things like that. Number 2, very important to plan for mental incapacity. A lot of people, when we think of estate planning, what's the first thing that pops into mind? Well, when I die or when my spouse dies, this is who gets all my stuff, and this is who's going to be in charge of giving them all of my stuff, all my assets, my bank accounts, my house, my car. A lot of times we do not plan, we fail to plan for the possibility of mental incapacity. And this could be different things. This could be somebody having a massive and sudden stroke. And within 10, 15 minutes, just like my dad was deceased, within 10 or 15 minutes, somebody is still alive, but they've lost their mental capacity, their ability to make rational decisions. This could be something that's more long and drawn out, like Alzheimer's or dementia. It could be a head injury that causes this to happen very quickly. So different things can cause this, but we want to plan for it. We don't just want to plan for passing away. And for mental incapacity, the solution to this is what are called a series of documents that are called powers of attorney. Okay. We have 7 of them that we provide as a package to our clients. But basically what we want is that if in the blink of an eye, somebody becomes mentally incapacitated, we want for a family member or a friend, whoever it is, to be able to step up immediately without hesitation, without delay, without having to go interview attorneys, hire an attorneys, wait for the court system to take its course for what we call guardianship. Okay, we're trying to avoid guardianship through the court system. The powers of attorney allow that family member to step up and immediately start making medical decisions, get medical records, manage finances, pay bills, receive income, sell the house, sell the car, whatever it is that makes sense that needs to be done. If you don't have powers of attorney, and I would add, if they're not drafted by a Texas lawyer, and I would say more or less if they're not within 5 or 6 years of being drafted, because the laws can change, you're at a great risk that if you or your spouse or your parent becomes mentally incapacitated, you're going to have to go hire an attorney to go through the guardianship system through the probate courts in Texas. And this is expensive. This is time consuming. It is stressful. It is. I also help clients with that into things. I help clients through the court system, and I help clients set up estate plans. And it is a million times less stressful, easier, and quicker to avoid the court system. I've got numerous cases with probate courts in the area right now that are kind of nightmares, some of them, for me and for the family, for different reasons. But setting up to avoid the court system is an endeavor that will really benefit whoever's going to be handling things when you pass away or when you become incapacitated, or if you're the one that's going to be handling things because it's your spouse who passes first or becomes incapacitated. It's going to dramatically help you. So we really recommend powers of attorney drafted by a Texas lawyer within the last 5 or 6 years. Next is probate. So I just kind of talked a little bit about that, but probate court does 2 things, okay, in Texas. Number one, it probates estates. It has estates pass through the probate court so that after somebody passes away, another person has the authority to command their assets, to go to the bank and get the money, to go to the retirement company, access the 401k, to put the house up for sale and to sell the house, to sell the car. You need somebody that will step into the shoes of the deceased person, and they can do what that person could have done. They can sell the car, sell the house, get into the bank accounts, distribute that money to who it belongs to. That's the number one reason the probate court's there. A secondary reason is what I was just talking about with guardianship. It's for the people the adults who become mentally incapacitated that need a decision maker because they can no longer make their own rational decisions. If the family has not set up to avoid the court system, then the family will have to go through probate court. Again, it is expensive, it is time consuming, it is stressful. Sometimes it's less stressful than others, but it's even in the best case scenario, it's a lot more stressful and time consuming than having the proper documents in place to avoid it. Worst case scenario can get really aggravating and very stressful. So we want to avoid that at all costs. But number one, the way to avoid probate court for mental incapacity, like I said, was powers of attorney. The way to avoid probate court for somebody passing away, you actually have some options. So let's kind of look at that. So what happens in Texas if I pass away this weekend, something happens to me, I'm in a terrible accident, I'm gone. Let's take the worst case scenario to the best. The worst case scenario for my wife, for my family, is that I die with no estate planning documents at all. I don't have a last will and testament. I don't have a trust. I haven't done any beneficiary designations on my accounts. I just pass away and nothing's been done. My wife is going to have to go through a expensive, stressful, time-consuming process that's just not going to be fun, so that she can get the authority to sell our house, to sell the car with my name on it, to access financial accounts like retirement type accounts that just have my name on it. And so that I'll just kind of throw this in as a quick blurb. If a lot of people think that if they're married and the couple owns a house together, well, if my wife dies or my husband dies, I just get I just get the house and I don't have to do anything. I don't have to worry about anything. That is not exactly true. You can stay in the house, and as long as you pay the property taxes, nobody's going to come bother you. Nobody's going to try and kick you out, presumably. But if you go to sell the house, you're not going to be able to. If you pass away and your kids want to sell the house, they're going to have to probate your estate and your spouse's estate. So with even joint marital homes, the deceased spouse is entitled, and we have to do something to get them off title. So keep that in mind. Okay, but we have the worst case scenario of going to court with no documents whatsoever. Okay, very expensive, very time consuming, very stressful. Then we have the next best scenario, which is a last will and testament. Okay, I call it the Model T Ford of estate planning. It's a lot better than walking, meaning it's a lot better than not having any documents at all. But it doesn't have AC, it doesn't have a radio, it doesn't go very fast. So it's kind of this antiquated machine that's better than nothing, right? A lot of people, but it is a lot better than nothing. A lot of people think that a last will and testament allows us to avoid the court system. And they think, well, I've got a will, so and the husband always thinks he's going to die first. So when I die, then my wife just gets everything and she doesn't have to do anything. That is 100% incorrect. That's more of a trust type device that accomplishes that. The purpose of a last will and testament is to go through the court system. Okay, it's so that you hire an attorney, you go through the court system, then the person named as executor under the will will be given the authority from the judge to sell the house, to access the finances, to sell the car, to do all the things they need to do. So last will and testament does take us through the court system. However, as long as the will is in good shape, meaning usually it's been drafted by a Texas lawyer in conformity with the laws of our state, it's going to go through much quicker, much cheaper, and much less stressful than not having a will. So it's much better than nothing, okay? Much better. What's the next best thing that we can do, though? What's better than a will? Well, one thing is to do death beneficiaries. With all of your financial accounts, you can do payable on death and transfer on death beneficiaries, so that your assets can pass without going through the court system. So if I go to, let's say I have 4 different financial institutions that hold money in my name, and I go to all of them because they all will let you do this. And I say, I want to do a payable on death beneficiary. I want to leave my wife and then my kids as my beneficiaries. I fill out some forms that they give me, they put it on file. And when I pass away, my beneficiaries simply need to present my death certificate to the bank, and they'll give them their money. No court system, no attorneys involved whatsoever. Okay, you can do that for all of your accounts. It's like life insurance, right? The purpose of having life insurance is to have a death beneficiary. Otherwise, why in the world would you have it? But you can do that same concept with these accounts. Second thing that's a big topic, big item here, is real property. So is there a way to pass down real estate without going through the court system in Texas? And the answer is yes. There's now 2 ways, and we're going to talk about the beneficiary way, the death beneficiary. There's a deed that can be drafted. This is as of about 5.5 years ago. It's been allowed in the state of Texas, maybe 6.5 now. But it's called the transfer on death deed. Okay, just like any other, where you deed your property to another person. Normally, you're doing it because somebody buys it from you, but you're deeding it to your beneficiary, your loved one, your family member, and it gets filed with the court system, or excuse me, it gets filed with the county clerk, but it does not take effect until you pass away. So until you pass away and somebody files an affidavit of death and a certificate of death, you obviously still own your property. And then your death triggers the property being owned by the beneficiary. They don't have to go to court. Okay. So this is something that can be very helpful. With your automobiles, the Texas DMV has a in-house beneficiary designation form that you can use to leave your automobile or any licensed vehicle. So this could be a boat, an RV, a motorcycle, a car, a truck, whatever, 18-wheeler. But you can leave it to your beneficiary, and they don't have to go to court. It's the path of least resistance, very nice, easy, and smooth. We keep a stack of them on file at our office, and we give them to all of our clients. You can also find them and get them from the DMV directly. Okay. Okay. There's one more way we're going to talk about to pass down your estate after you pass away, and this is I'll just say the best way. Most people think, I think, and a lot of other people do. But it's to have a trust device, and we'll just talk today about a living revocable trust. What can a trust do for us? Number one, it can allow us, our family, to 100% completely avoid the court system, period, end of story, with all of our assets. Nobody has to go to court. The trust passes down the assets to the spouse or to the next generation privately, quickly, cheaply, with no attorney or court involvement. Okay, it's a great thing. The trust can also help us avoid the federal estate tax, or what's called the death tax, if that applies to us. Right now, there's a lot of people that it does not apply to. What we're kind of hearing in the news cycle is that probably in the next year or so, it's going to apply to a lot more people. They're probably about to drop that threshold dramatically, as well as increase the percentage of the estate that's taken. So a trust can help us avoid that. The third thing that a trust can do can be great for some people that no other estate planning device can do, period. So a will cannot do this. A beneficiary designation cannot do this, is allow us to spread out distributions to beneficiaries over time. So instead of, well, Johnny and Susie get 50% each of the estate as soon as I die, and let's say it's $1 million. Johnny gets $1 million, Susie gets $1 million. But wait, Susie is going through she's in a bad marriage, constantly on the edge of divorce. Johnny has been dealing with chemical dependency issues, and giving him a lot of money might really send him over the edge. It doesn't matter. If you don't have a trust device, your beneficiaries are getting those distributions outright, lump sum. They're getting it, period. It doesn't matter how messed up or dysfunctional they are in life. Okay. If you have a trust, you can distribute smaller amounts of money over time. You can make the distributions dependent on certain things, dependent on getting a college education, depending on completing a rehab program and taking, a year of clean drug test, all sorts of different things that people can do. The creativity is really pretty limitless. So a trust can really help us with that, with beneficiaries who are maybe financially not sophisticated, not disciplined, or have problems. Also, I have a lot of clients that want to leave some money to grandkids, but they want it to maybe be used for college, or maybe when the grandkid is older, they don't just want to dump, a couple $100,000 on a grandkid when they're 18 years old. So a trust can help us accomplish all those things, guys. Those are the different ways, though, that we either go through the probate court or avoid the probate court in the state of Texas. Okay, next, attorneys and fees. So let me tell you this. Number one, we highly recommend, if you're a Texas resident, very important to work with an attorney. Number one, not get on the internet and do the cheapest thing you can. We have seen so many bad situations with internet documents. Some of them we were able to remedy because the person hadn't died yet, or the person had not become mentally incapacitated yet. Some of them were not. Lots of bad situations with that. But you want an attorney. Furthermore, you want a Texas attorney. to draft your estate plan if you're a Texas resident. And then third, my recommendation that you find somebody that's the focus of their practice. Just like with doctors, right? Are you going to go to if you have an eye problem, are you going to go to a general practitioner? Are you going to go to a knee doctor? Probably not. You probably want an eye doctor. So same thing in the legal world, things have become very compartmentalized. There's a lot to know about any given topic in the law. It's endless. It really is almost endless. So it's important, I think, to work with somebody that's really their primary focus. Okay. And I'll tell you something else. Like I said earlier, I set up estate plans for families. I also take families through the probate court system. In addition to probate court being much more stressful, much more of a nuisance. I mean, gosh, sometimes it drives us crazy. Some of the things that go on and that we have to do, and this isn't right, and this is wrong. But in addition to that, it is always less expensive to set up an estate plan than to go to probate court. So in addition to relief of the headache and the stress, your family, your estate in the end will spend less money on the estate plan than the probate court. So it's almost kind of a no-brainer. I just think there's a lot of people who, the last thing we want to sit around thinking about is our death or incapacity, or we're going to have to go to a nursing home, and all these things that I make clients think about so that we can plan for them. I think a lot of people just like to avoid the topic, but you do so at either your peril, if you're the one left holding the bag when your spouse passes, or to the peril of your spouse or children if you go and they have to kind of pick up the pieces. Okay, but it's definitely worth it. It's like anything else in life. Spend a little bit of money, get it done right. You're going to save money in the long run. Okay. So also, you don't need all the answers right away. I have a lot of people will say, well, I want to come in and see you, but I'm not really sure yet on exactly what I want to do. I'm not really sure yet on exactly, who's going to be my trustee or who's going to be my power of attorney. And let me kind of figure that out and I'll come see you. And what I tell them is, look, that's part of why I'm there. I mean, I've seen so many families, probably thousands of families that I've met with, that have all sorts of different scenarios. I've seen families get very creative and ways to handle things, different situations that can come up in life. And so I think that it's something that the attorney should be there for, is really to help guide you through that. Okay. I think that's very, very critical is that you want the attorney to help walk you through that. And you don't feel like that you just need all of the answers right away, because you don't. Let the attorney help you with that. Next, so a will is not always enough. And we just talked a lot about that. I talked a lot about that. You listened. But again, let's just kind of recap this. What can a trust do that a will cannot? A trust helps us avoid the probate court system, period, end of story. A trust can help us avoid the federal estate tax if it applies to us. A will cannot. A trust can help give us a distribution schedule that is something different than just, I'm dead, you're my kid, here's the money, all the money, good luck, right? We can get super creative. We can custom tailor each beneficiary's distribution schedule to their situation in life. And like I said, people come in and my son or my daughter is the greatest person in the world. They've completely got it together, very mature, very responsible, to, my kid is just a pretty good person, but he or she is in a terrible marriage right now. I'm worried they're constantly on the verge of divorce, or, my kid has been struggling with alcohol or drug abuse. My kid's he's just a bad money manager. He's 38. He's just never really matured financially. And so I hear everything, right? But it's a will, if that's what you're going to have, that gives somebody their money outright right away, and it sends them through the court system. And for some people, that's just not a good idea. So it's about the plan, not just the documents. So, the documents are simply a vehicle to enact the plan. And so it's not just, oh, look, I have these documents. Isn't this great? I've got, these 5 or 6 documents here. It's about sitting down, developing a plan that, like I was saying earlier, that makes sense for your family, that is custom tailored to your family, your family's assets, your family dynamics, your wishes for your family after you're gone, and then fitting the documents in a way that makes sense to carry out the plan. So we don't want to just think of this as, well, I just need to have these documents, and then I'm in good shape, and it doesn't matter if I get them from the internet or from, I copy it, or my uncle my brother is an attorney in Oregon, and he's a personal injury attorney, but I think he can draft a will for me, a Texas will. We want to have a good plan in place. And once we have that plan in place, we want to come up with the proper documents that fit Texas law to enact that plan. Okay. And that's why, like I said at the beginning, every family's different. This is not a one size fits all situation. At our firm, what we do is we always offer a complimentary consultation to any family or individual the very first time. Okay. So that's going to be on the house for up to an hour. You'll have an hour of my time, and we'll talk about your family, again, your assets, your family dynamics, what your desires are. And we'll see if we can come up with the best way possible using Texas law, Texas documents to achieve that. Okay. So it's real critical. We also offer at our firm every 2 years, we have our clients come in for a complimentary review. And if you're a client of another firm, I want to tell you that we think at a minimum, you should have your estate plan reviewed every 5 years. Okay. Because even though you might think, well, nothing's really changed that much, probably something has. Usually, even when I have my clients come in every 2 years, sometimes my clients are shocked once we start talking. They're like, yeah, I have had 2 more grandkids, and or yeah, that kid, my son did get a divorce. We haven't really thought about that, or I had that investment that just blew up, and yeah, I didn't have that $1.5 million extra when I came to see you last time. So a lot of things can change. We bring our clients in every 2 years, but we think at least every 5 years at a minimum, you should see your estate planning professional. Okay. And again, the main thing is just do it. Just talk to the attorney, start the conversation. Don't try and wiggle out of it and say, well, let me go home and think about it for 9 months, or you say a week, and then it's always going to turn into 6 to 9 months. Just get it done, because whenever we get to the end of the process, I cannot tell you how many my clients tell me that was so much easier than what I thought. I'm so glad I got this done. Because once you get it done, it's finished. I mean, it's like a project at your house, right? It's, if you're gonna, paint some of the walls of 3 different bedrooms, and you're kind of like, gosh, this is going to be a hassle. We got to cover the furniture. We got to pick out the paint. This is going to take a while. But then once you're done, you have that sense of satisfaction of, I did it. The walls look great. I don't need to worry about this for a long time. It's the same thing with estate planning, except you hardly do anything. We do 85% of the work, but a lot of people get that sense of satisfaction that in case something happens, our family's prepared. And so it's a good feeling. I've had it myself when I did my own plan and when I changed my own plan. Okay, so now we want to go to questions. The questions and I think there's an area, and we might get Zoe in here to help, but I think there's an area where you guys can type your questions in, and I'm happy to answer questions about anything that I talked about, or if there's something that I did not discuss that you're curious about, that's fair game too. If I can answer the question, I absolutely will. So Zoe, if you want to, last time I think you read me the questions. That worked pretty good.
Yep, that's exactly what we'll do again.
Okay.
I like the old age saying, if it's not broke, don't fix it.
Yes, correct. Right.
All right. So yeah, guys, you can put your questions there into the chat. If you've never used the chat function, if you put your mouse on the screen at the bottom of your Zoom screen, you're going to see the word chat with what looks like a text bubble, like in old cartoons. Click that and it'll pop up chat bar to your right, and you'll click where it says type message here. You just type away, hit enter, and it'll pop up for everyone to see. So I do have some stuff in here a while. Um, Someone needed to know about how to title the DMV assets to avoid probate. We had a little bit of disconnect there. Um, and stuttering in the audio at that point. Is there a form name or number that would help them figure out what they need?
Yeah, so for the Texas Department of Motor Vehicle, they have what's called a beneficiary designation form.
Okay.
And that's what you need. And if you've ever done a beneficiary designation for life insurance or for your retirement, it's similar to that, except it's for your car. I will tell you, I don't know why, but I guess for just to make the form all on one page, they only allow for one beneficiary. So if you have multiple kids, you're just going to have to pick one. But yeah, it's the beneficiary designation form through the Texas DMV. You can find it online. I don't know exactly where, it's somewhere on their website. And I'll tell you, if you go in and ask for it, the DMV and what the given employee knows about something is all over the map from what I hear. So you might go in and be told, yeah, here it is, fill this out and yada, yada. Or you might be given a blank look and told, I don't know what you're talking about. I've never heard of that. So I'll just warn you of that. But you can also find it online as well.
Perfect. Okay. So someone wanted to know, are your cash assets subject to estate tax if they have assigned beneficiaries?
Yes. So that's a great question. And yeah, anything that's gonna pass to a beneficiary, whether it's through a trust distribution, whether it's through a beneficiary designation, whether it's through the court system and the last will and testament, the IRS is all going to make that fair game for the estate tax. I'm not going to spend 30 minutes getting off on a tangent about this, but I'll just say briefly, the way that a trust can help us avoid the estate tax is that the money, the overage amount, the amount that you get up to where you don't have, if you release X amount, we don't have to pay taxes. So we hold back, let's say $1 million. The trustee will hold back the amount that would be taxed because it's over the limit and wait and hope that at some point in the future, the law changes and then we can release that and we're not going to be subject to the estate tax. So different, but there's more to it. But in general, the answer to that is definitely yes. And let me add too, there's several huge misconceptions in estate planning. And one of them is that life insurance is not taxed. It's not subject to any tax. 100% not true. It is not subject to the federal income tax, okay? But it most definitely is also lumped in and can be subject to the federal estate tax. So you have to include, when calculating the estate tax, you have to include any life insurance proceeds in that amount.
Interesting. Okay, that's great information to have. Now, if I'm paying attention and I'm remembering correctly from some of the last talks that you've done, now there is a certain amount in your assets that you have to have before you get the estate tax. Is that correct, or am I thinking of something else?
Yeah. So, and I just saw a question from I lost the name, but somebody was asking about, I think, how much money do you have to have, or what's the threshold? So. Right. Number one, I'm going to tell you what the threshold is right now, and everybody's going to laugh because most of us don't fit in it. If you have one beneficiary, it's at about 10.8 million. Anything under 10.8 million is not taxed. If you have multiple beneficiaries, it could be 2 or it could be 18. It's just doubled, right? Multiples doubled. Okay. So right now it's set at a threshold that doesn't impact many people. It's also set at, I think, about 40%, 42% if there is overage. Nobody knows for sure, but the things that have been said over the past few months and et cetera about the new government in Washington, D.C. is that we can maybe expect it probably to drop to 3 or 3.5 million in the next year to 18 months for a single beneficiary. And normally for multiple beneficiaries, it's doubled. So I don't know what this government's going to do, if they're going to double it. Normally that's customary. but it's a substantial decrease. It's a 1/3 decrease. It's going to impact a lot more people.
Yeah.
And also it's rumored that, or I don't know if I call it rumor, but speculation based on things that have been said, that the amount could go up to 48%. So that overage would be taxed at 48%. So it will be something that will impact a lot more people. It'll impact, I don't know the best way to put this, but we'll say low-level millionaires, a lot more low-level millionaires, barely millionaires, you know, a lot of them now will be subject to the estate tax, whereas before you had to be in the last few years, you had to be in double digits with your millions before it impacted you. So that's not that many people, but that's probably about to change in the next 12 to 18 months.
Okay. All right. So what is the average cost for estate planning, Brandon?
So that's a good question. I'll say this. So if it all depends on what you're doing, right? We have packages. If somebody is getting a last will and testament package, and you're a married couple, from being a single person to a married couple, you're probably going to spend somewhere between $1,200 and $1,800, depending if you're married or single. That's the powers of attorney and the last will and testament. If you're going to get a trust package with all the powers of attorney and the pour-over will, it depends on if you're single or married and how advanced and sophisticated or basic the trust is, and that all depends on things. But that ranges more in the 3,600 to 5,600 range, depending on how complex the trust needs to be or how basic it can be. Most of us can get away with a basic trust, right? The people that need a more complex trust, well, some are middle income if they're trying to avoid Medicaid. There's some Medicaid crowd that needs an advanced trust. And then some are just, people that are very high net worth that need a lot of work. But those are kind of the ranges right there, depending on circumstances.
Okay. What would it cost to have a review of their estate plan?
Okay, so that's a good question. If somebody wants to come in, I do this a lot, and talk to me for an hour and give me their documents and let me take a look at them and talk to them about it, that doesn't cost a dime. That falls under the complimentary consultation bracket. So we're happy to do that. If somebody says, no, I want you to read every single word of my estate plan. Just, I don't want you to sit, I don't want it to be you kind of look through it and talk to me. I want you to read the whole thing. I charge $350 an hour for that. And so depends. It might take an hour of my time or it might take 2 hours. So it just kind of depends on what the person is wanting.
Okay. That we might need clarification for this one, but she said, what if your parents are living on land that belonged to their family?
Well, so the first question would be, did your parents probate it into their name through some way, or was it deeded to them through a trust, or are your parents just living there and it belonged to the grandparents? If the answer is it was deeded into their name, well then, and I don't think that's probably what she's asking, but that's fine. It's great. It doesn't matter who had the property. If it's no, they just lived there, and my dad's parents died, 20 years ago, and they just lived there. Nothing's ever been done. And he has 5 brothers, and 2 of them have died, and 3 are alive. Then all the brothers are going to own it together with the children of the deceased brothers. Okay, so that can become a huge mess when we have these large families. Not going through, this is why you want to always go, even after your spouse dies, and the probate police aren't going to come kick you out of your house just because your spouse died, but you still want to go ahead and probate and get it out of your spouse's name. And that's why, is because we see these families that they will go generations where, the grandmother dies and then one of her kids lives there, and then she dies, and then there was 8 kids and there's 19 grandkids. And then nobody wants to live there, and a family member approaches me, and it's a total nightmare. It's a fiasco to clean that up. And so but the answer to that is probably they would need to go back now while your parents are alive and get a lot of that probate work done so that
Right.
they can leave it to their kids in good shape and that you guys don't have to deal with a mess.
Right. Perfect. Um, I believe, if I know correctly, we are going to talk about this subject in the future, but do you set up special needs trusts for disabled children?
Yeah, absolutely. And we are going to talk about that in the future in greater detail.
Yep.
That's extremely important. Let me just say quickly why it's important. If I'm a special needs person, and whether I'm an adult or a child, because if I'm a special needs child, I may be on SSI disability or Medicaid in the future. But if I'm a special needs child or adult, and I'm either on SSDI or there's a good chance I'm going to be on it, if I receive an inheritance and I'm on SSDI and maybe some Medicaid for health insurance, I will be kicked off of Medicaid and SSDI. I will have to spend down my inheritance to $2,000 before I get that back, that funding back. If I am on SSDI and I'm on Medicaid and I receive an inheritance that goes into a special needs trust on my behalf, not to me directly, and my trustee does the proper job of paying for things on my behalf out of the trust that are allowed by federal law, then I will keep my SSDI, I will keep my Medicaid, and I will always have that trust there to pay for certain things like clothing, toiletries, personal items, things like that. So special needs trust, I think, are super critical for families that have a special needs child or adult. So great question.
What are the types of POA, power of attorneys you mentioned?
Okay. Healthcare power of attorney. That's for all manner of healthcare decision making, from the very small to the very large. Number two, HIPAA release form, which is required by federal law so that the medical power of attorney can get medical records. Okay, so we want HIPAA. Also, advanced medical directive. That's where we can predetermine if we're in a serious scenario on life support and it looks like the end is imminent, or it looks like that we're so damaged upstairs that we're probably never going to come back to normal and be able to function, we can elect whether or not we want to be removed or kept on. There's also a property power of attorney for real estate, a statutory durable power of attorney for everything else, asset management, retirement, bank accounts, taxes, things like that. Then we have a declaration of guardian, where it's kind of our backup document, where we say, if I have to have a legal guardian, this is who I want it to be. We go ahead and clarify that to the court so we don't have family feuds over that. That's another big thing, guys. Powers of attorney, wills, trust that are done properly can really help derail family bloodbaths and family feuds, because you've probably all seen it or at least heard about it with a friend. We see a lot of those in our industry. People get real greedy when it comes to this money. People become controlling sometimes with the parent. They get into these power struggles with their siblings. A big red flag, honestly, is blended families. This happens for sure in traditional families, but in blended families, it's 20 times more likely to happen. So, anyways, just kind of a quick sidebar there. You really want to have good documents in place saying who's going to be doing what, who's going to be getting what, so we avoid family bloodbaths. But the last power of attorney, and maybe the least optimistic, authority for disposition of last remains. So it's going to be your choice in order of people who would handle your last remains, and then your burial and funeral instructions, instructing your family on what you would like to have done, whether you want to be cremated or buried, you want your ashes scattered somewhere, do you want to be buried in a certain location, things like that.
Right. Okay, if I have a living trust, should my assets, car, condo, bank account, etc., be listed under that living trust name?
So number one, out of everything you said, the only thing I don't like being put in trust is the car. We like to use those DMV forms I was talking about.
Okay.
It's kind of a long explanation as to why, but just trust me on that. You like the DMV beneficiary forms are better. Everything else, if you have a trust, you want to be connected to your trust. But understand, It's not enough just to list it. You can't just say, well, here's my trust and here's my list of all my stuff. So that means it's in the trust. It's not the case. We actually have to retitle things, do beneficiary designations to the trust. It's a process called funding that we take great care to help our clients with, because we want for all of our clients to be the ones who are funded.
Right.
For example, if I, get hit by a beer truck tomorrow, or I, win the lottery and disappear somewhere, I want, when my clients go to other firms in the future, I want for their trust to be in great shape. I want for their trust to be the ones that are funded, and that other people can say, hey, the McGee Law Firm, they do a good job. Because we've had so many clients come in with trust, older trust in here, that are completely unfunded or partially not funded. And they'll say that just wasn't emphasized that much. The attorney didn't, this was 9 years ago, and the attorney just didn't say that much about it. So that's called funding. There's a lot more to it than just making a list of what your assets, your property is. But it's very critical. Okay. But that being said, we do always want a property list in the trust so that your successor trustee knows what you have. We want, when you die, we want them to be able to look in your notebook and see, oh, this is what everything that they have, but it needs to be connected to the trust. Okay, guys?
Okay. And did you say there's a beneficiary designation form for a house?
Yeah, but it's not a form. It's a deed. It's called a transfer on death deed. This is not something, I have seen one client who came in with a form from, I think, a county in South Texas. But I don't recommend that. This is something that we recommend hiring a law firm to draft for you. Just like if you were going to sell your house to somebody or gift it to somebody, you'd want it done professionally, you'd want it done right. It's relatively inexpensive compared to other things that go on in the legal world. It's really not that much money, but it's called a transfer on death deed. It's not a form. It's something that it's best being drafted, in my opinion, by a law firm.
Okay, wonderful. And then do you need the designation forms for a fully owned car? And even though you said there really is no form, but a fully owned house, would you do the same thing?
Okay, will you read that to me again?
Do you need beneficiary designation forms for a fully owned car?
Yeah, because number one, if you don't fully own your car, you can't do a deed, because usually, maybe not all the times, but usually your car title is held back until you pay it off. So if you haven't paid off your car, you probably don't have title yet, which means you can't fill out a beneficiary form. But yes, if it's paid off, you absolutely want to do that. Otherwise, it can be a hassle. I've had to go probate a will several times just so that my client could get ownership of a car. It's really frustrating. I've had other clients who things have worked out better than that. But if you have that form done, the person who's going to inherit that from you is guaranteed to have the easiest time possible. So yeah, if your car's paid off, please do a DMV beneficiary designation form. Yes, and that's any titled vehicle: boats, trailers, motorcycles, anything.
Great. All right, we got a little bit more clarification on the property question. So what if your parents are living on property that belonged to their parents, but there was no will? Taxes have been paid, but it's still in the parents' name, and the parents are the only, from what I can tell, living child still.
So I'm not going to say, based on what I just heard, this is for sure what you should do. I will say probably one thing you could do is called an affidavit of heirship, that your parents could do the affidavit of heirship. Again, it's something that's relatively quick and inexpensive in the legal world. It's a lot easier than going to court, a lot cheaper than going to court. So if I talk to this individual and all the scenario set up the way it seems that it is, I'd probably say you want to do an affidavit of heirship. There's other things that can be done too that are usually more in depth, more expensive, more time consuming, that we sometimes have to do depending on circumstances. But there's something your parents can do. There's something that they'll be able to do legally in Texas. If it's an affidavit of heirship, that's the best thing. They really need to talk to estate planning probate attorney like myself. They really need to talk to somebody and get some good guidance and get things done so that if they're going to leave it to you, you're not dealing with a huge mess at that point.
Okay. Someone asks, is that the same thing as a deed without warranty that must be filled out at Dallas County Records?
I don't. So I'm not going to say that's not an accurate description, but I'm also not going to say it is. So I've never referred to it that way. I've never heard it referred to that way. It's called an affidavit of heirship. It does get filed with county land records. You don't have to hire an attorney to do that, but for the cost, it's a very smart thing to do because it doesn't cost. I mean, my firm and probably plenty of other firms doesn't cost that much. And it has to meet certain criteria because you might create an affidavit of heirship, you might file it with the county, you might think you're in good shape, and then 12 years later, you may go to sell that property and you may be denied the ability to do so by the title company because it's not done properly. So we want to do that with a law firm. The way you described it, kind of, sort of, yeah, but I call it, it's better to call it an affidavit of heirship because that's what it actually is.
Okay, great. I think that is all the questions that we have right now. So Brandon, as always, thank you so much for joining us. Very informative as always. I will get my my mother-in-law to listen to me one of these days. And I know that we'll be scheduling some more stuff in the future. And one of the things that has been discussed is doing a special presentation on those special needs trusts. So
yeah, we'd be really happy to do that. Very important for the families that deal with that issue. And thank you so much, Zoe and Celebration, and thank you guys for listening. And I hope it was very informative for you guys. And like I said earlier, if you ever want to have a complimentary consultation, just give us a call and look us up on the internet. I think our number may be down there on the screen.
Yep, 817-899-3286 is the phone number. And somebody asked what your name is. His name is Brandon McGee with McGee.
So I am the owner of the firm, and I am the person that you would be talking to if you come in, and be happy to talk to any of you guys. It doesn't matter how big or how small your estate is. Everybody that has things, we want to find the best way to help pass that down to your family. And there's a solution for everybody. So thank you guys so much.
Thank you, Brandon.